Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic is it time to behave? A conversation with Dr. Angela Zhang on China's approach to data and privacy. As the amount of data on persons, companies, and governments has grown exponentially, so too have efforts to regulate the use of data. In this episode of Our Curious Amalgam, we'll explore China's approach to data privacy, recent changes to its laws, and how it compares to other jurisdictions. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Christina.
So, data and privacy laws in China. Why are we talking about these?
Well, it seems like all the jurisdictions have been copying each other's notes. They have been trying to legislate more and I guess more aggressively to protect consumers' data and privacy. That seems to be the trend to go. And in China, we do have a lot to watch, especially in the year of 2021. There has been major laws coming into effect, and new proposals and also legislations that seems to be just going to enhance the data and privacy realm a lot more aggressively. So we really need to know where is it going, how it's going to affect the business and consumers in China and sometimes outside of China, a lot of times outside China. So it's time to learn about it.
Great. And who do we have as our guest to speak on this topic?
Our guest, Dr. Angela Zhang, is an associate professor of law and director of the Center for Chinese Law at the University of Hong Kong. Professor Zhang, or Angela, I'm just going to call her Angela from now on, is very much an academic rising star. She has broad research interests in law and economics, and particularly she has focuses on antitrust and Chinese law. Angela is well published, including a recent book titled Chinese Antitrust Exceptionalism: How the Rise of China Challenges Global Regulation, in which she described how China's approach to regulation on antitrust and perhaps beyond is reshaping global antitrust regulation. And then Angela has won multiple awards, including Concurrence Antitrust Writing Award for 4 times. She's also regularly interviewed for questions on Chinese laws of antitrust, of data, and privacy. So she's the right person to talk to.
Sounds like it. Angela, welcome to the program.
Thanks for having me.
Angela, we're really happy that we're finally doing this. We thought about doing this when we first read about the first major law coming into effect. Apparently, there's more than one. So let's start there. On a high level, is China tightening its laws and regulations on data and privacy, like in many other regulations?
Yeah, that's a very good question. So you all know that since October 2020, the Chinese government has sort of tightened regulation on many spheres, particularly the tech sector. So we see a lot of new laws and regulations being rolled out in the past year, and data is one such area where you see a lot of fluid developments.
And would you say China is going a little more aggressively, or obviously we're trying to simplify things, but is that fair to say?
Well, I mean, definitely more aggressive than the United States. I mean, so far the U.S. haven't had a major comprehensive data privacy law at the federal level, where China now, in the past year, China adopted 2 national law. One is the data security law that went into effect in September this year, 2021. And then the personal information protection law just came into effect, last month. And, in 2017, China's cybersecurity law went into effect. So now we have 3 major data law at the national level, which form a very comprehensive framework for data regulation in China.
We'll go getting to the comparison between China and U.S. and its data regulation a little bit further later. But let's just try to figure out how the three laws that you've mentioned work together. So if I can recap a little, there is a 2017 law called the Cybersecurity Law. There are two 2021 laws. One's called a the 2017 cybersecurity law, and then 2021 is data security law. And then there is also another 2021 called the personal information protection law. Is that right?
Yes, correct.
And how do they work together?
So these form the three main pillars of Chinese data regulation. The older one, the cybersecurity law, is more of a general body of law that deals with cybersecurity issues like network security, information security. It does overlap quite a bit with the other two laws, but you can see its major focus is to safeguard, national security. The data security law that was passed this year, it focus on data processing activities, including both online and offline activities. So that's different from the cybersecurity law, which only deals with cyberspace issues. And the data security law classified data into different categories and impose more obligations on data processors that are in possession of national core data and important data. Now, when it comes to the personal information protection law we just talked about, this law is very much closely modeled after the EU's general data protection law. And so people call it, China's GDPR. And the Wall Street Journal said this is one of the toughest data privacy law in the planet.
Oh, wow. So it sounds like it does combines the most restrictive aspects from other jurisdiction. Now you have the, what do you call, personal information protection law, or PIPL. That's the China GDPR. And then the data security law, as you said, it governs online and offline data processing,
yes.
right? Apparently, that's not all. Are we looking? Are we expecting any other major regulations or draft regulations anytime soon?
Oh yes, there are a lot, and there are more on the way. And there's so much going on that we were joking the other day that it's impossible to keep track of what's going on, even for us, because every day there will be new laws that is rolled out. And if I could think of, two very important ones to look out for is, one is the measure on a cybersecurity review mechanism. We actually have one version that was promulgated in 2020, and that actually formed the legal basis for China's Cyberspace Administration to conduct its investigation on Didi. As you probably have heard about the Didi case, right? I mean, Didi,
and Didi is a car hailing service. It's sort of like equivalent of Uber, and that's really the largest one in China right now.
Yes, correct. So Didi went listed in New York in July this year, but 2 days after its listing, China's Cyberspace Administration conducted a surprise cybersecurity check investigation into this firm. And so this measures on cybersecurity review mechanism adopted in 2020 was the legal basis to conduct this review. And then after the Didi case, was initiated, the Cyberspace Administration issued another draft amendment of the 2020 measures on cybersecurity review, which significantly broadened its scope and tightened the overseas listing of internet companies. So now it requires tech firms with over 1 million users to go through a regulatory approval if they intend to list overseas. So that effectively add another hurdle for firms seeking to list overseas. So this major amendment is on the way, and the other really important regulation is the draft. Yes, go ahead.
And let me let me get a little more information out here. So the regulator, I guess in the DD case as well, is Cyberspace Administration of China,
Yes.
right? CAC.
Yes, correct.
And is there other regulators in play here?
Well, when they conducted cybersecurity check, there are simultaneously 7 that was on site on DD in DD's company because the cyber security investigation is usually conducted by a cohort of regulators. We can talk more about the enforcement structure, but it's really complicated. So CAC is the main agency in charge with policy coordination and a lot of the legislative activities, but there are a lot of other Chinese ministries involved in the DD case as well.
Sure. And then go ahead. You're going to talk about.
So the other really important regulation is the draft internet data security measures that was just released by CAC about 3 weeks ago in mid-November 2021. And this is an administrative regulation, so it will ultimately be promulgated by the state council. So it's a law of pretty high, status, legal status. It's not just regular guidelines or implementation guidelines or measures. It's going to be administrative regulation, so it's going to be a very important law just below the national law we just talked about. And this regulation provide very broad and very detailed practical guidance on the enforcement of the 3 major national laws that we just talked about, like the cybersecurity law, the data security law, and the personal information protection law. And so, we definitely need to keep a very close eye on the development of this new regulation, and because it does provide a lot of details into the implementation of these 3 major laws.
Angela, you mentioned, one of the regulations is applying to companies that are choosing to list abroad, which I thought was interesting. What's motivating some of these laws and regulations, and how does its application to different companies or who it applies to sort of shed light on the motivations for these regulations, protecting individuals, protecting companies, protecting governmental interests?
The main motivation is data sovereignty, and in that regard, China is definitely not exceptional in protecting its sovereignty interests when it comes to data issues. So, for instance, in the DD case, what the Chinese government was worried about is that DD might turn over sensitive data of its users to the American securities regulator, because as you probably know, during the listing process, DD need to go through extensive auditing by accounting firm, and that working papers might contain sensitive information such as the information about its suppliers of its major networks, infrastructure, as well as its software. And that type of information, if it is revealed to foreign regulators, might make DD's infrastructure and network more susceptible to cybersecurity attack. So that's a theoretical possibility, right? But you can understand where the Chinese government is coming from and why they were concerned about DD's overseas listing. So, and after the DD case, you see the Chinese government has significantly tightened regulation. You see in both the data security law we just talked about, as well as this, cyber review mechanism measures, as well as this new draft internet data security regulation. In all this law, the government have put an emphasis on the importance of scrutinizing cross-border data transfer, even regard to those kind of transmission of data to foreign regulators or judicial bodies. They will be concerned about data sovereignty issues.
So I want to come back to one more element in the DDA case. So the ramification there is that the company is somewhat prevented in its process of being listed outside of China. What about foreign companies? Are they facing fines, civil fines, criminal, uh, any any uh, any consequences for violations of any of these laws?
Well, I mean, if foreign companies work in China and are in possession of Chinese data and so become data processors, they will be similarly subject to the Chinese law. And even if the foreign company do not reside in China, but they are in possession of data of Chinese citizens, I think the law similarly will apply to them, just like the antitrust law, right? I mean, it has extraterritorial applications. So, but so far, we haven't seen many big cases of the violation of Chinese law. But remember, let's bear in mind that the cybersecurity law went into effect in 2017. It did affect quite a number of big American companies operating in China. Think about Apple, for instance, right? I mean, Apple was required to, save its data in China. So there is a data localization requirement in the cybersecurity law, and Apple, just like other companies in China, will be subject to, requirements and from the Chinese. From the Chinese authority on the request for data. I mean, for legal purposes, right? I mean, and I remember, according to, I don't remember the statistics very clearly on my mind, but I do remember Apple disclosed it's the data request from the Chinese authority before and after the promulgation of the cybersecurity law. And it seems that since the law went into effect in 2017, it was faced with more requests, and it's becoming a bit more difficult for Apple to challenge such requests. However, I do see the figure that Apple was able to, challenge some of the requests. It's not like what has been reported in the Western media that the firms in China can never challenge data requests from the Chinese government. It does seem that from at least the limited disclosure we have from Apple and other tech firms that have been successful challenge in China.
Mm-hmm. Mm-hmm. And let's go into another major topic that we have, which is comparison with other jurisdictions. And we have already done that a little bit with the U.S. And then in the U.S., there's one particular aspect I'd like to point out, which is that on a federal level, seems like data and privacy laws are very much described as in patchwork mode, like a lot of, especially when data involves certain industries or type of data, like financial or health, then it's particularly restrictive. Is that also true in China? Like I guess patchwork is probably, well, we're seeing more laws coming into effect and probably being designed, but is that more of like a comprehensively designed, but also patchwork in terms to catch whenever there is new concern for particular data or particular type of issues?
Right. Yeah, very good question. So definitely the enforcement structure in China stand out because there is no single independent agency in charge of data regulation in China, and the enforcement relies upon, as you described, a patchwork of regulators. So almost everybody is involved with data regulation in China. And at the central level, you have four major ministries. You have the Cyberspace Administration, which we already talked about, and the Ministry of Industry and Information Technology. We call it the MIIT, which has been a telecom regulator, but they do have functions in regulating data activities. And then you have the Ministry of Public Security, as well as the State Administration for Market Regulation, the SAMR. So this agency should not be, antitrust lawyers should be familiar with this agency because it's also in charge of antitrust enforcement. So this is really a large market watchdog in China with responsibility in many different areas of market regulation. So you have these four major authority at the central level. However, on top of that, you also have a lot of sector regulators that are also involved in regulating data activities of those companies in the relevant sector. Just to give an example, right? I mean, China's central bank, the People's Bank of China, we call it the PBOC, will have some authority in regulating data activities in the financial sectors. And actually, it is the agency that is leading all this, restructuring that is going on with China's Ant Group. Recall Ant Group, this famous company whose IPO was halted 2 days before its launch last year. And so the PBOC is leading the efforts to restructure this company, and a lot of the restructuring activities involve data regulation, right? I mean, the big question within is how, to what extent could it share its data with the central bank, right? I mean, and in October 2021, the PBOC promulgated credit information guidelines, which enable the authority to obtain more data from Chinese financial and non-financial institutions. So you see, right? I mean, the PBOC in the financial area is really a very powerful regulator in data regulation. And you can imagine, right? I mean, in other sector like electric car. I mean, China's the Ministry of Transportation will also play quite an important role with data regulation. So so it's not an overstatement to say almost everybody is involved with data regulation, and you basically have the same structure replicated at the provincial level. So you have both the central and the local regulators. Everybody is involved here with data.
I'm just going to put a side comment, and this is from me. Sounds like there's a patchwork, and also each patch is larger, and there is definitely some overlap between the laws. And you might disagree, but it looks like with many regulators getting involved, and they're all trying to play a role here, but there could be some overlap here. Another comparison we want to draw is with EU and its GDPR. So you have described the Chinese Personal Information Protection Law as the China GDPR. So with that all in picture, where does China stand? Is it even more aggressive than EU and US all combined, or actually with all these laws and then working together and the enforcement, right? We haven't really gone into enforcement in depth. Where does China stand?
Right. So it's a bit early to make the exact comparison, as you mentioned that, it's only a couple of months since the law went into effect. So we can't see exactly what the enforcement will look like. If we had do another podcast a few years down the road, I can give you a more accurate answer. But at least now, if we just compare the black letter law, we can already have some big picture idea, right? I mean, you can see the Chinese law does match the EU standard in many regards. And in some areas, the Chinese law is much stricter than the GDPR. And I can give you one, striking example. So the latest draft regulation on data security, which was promulgated just 3 weeks ago by the CAC. So it still remains a draft, and it's soliciting public opinions at the moment. The agency imposed a very strict requirement on app developers to obtain consumers' explicit consent before enabling the recommendation and the personalization functions in their apps. Now, even though the EU law also required consent, but they they don't require explicit consents, right? So if consumers are allowed to opt out of those functions, that will be okay. But the Chinese law would require explicit opt-in, and that could make a very big difference, right? I mean, for those of you who, I don't know whether you use iPhone, right? If you are an iPhone user like me, you may recall a few months ago, Apple changed its privacy policy and start asking its users whether they want the activities to be tracked by the apps, right? And I remember, I of course chose not to be tracked, right, as most of the other users. So, but before this change of the privacy setting, Apple actually have this option for users to opt out, but few users, similar to me, bother to go through this privacy setting to figure out how to opt out, right? So whether you ask or not make a huge difference, right? So opt in or opt out make a big difference. And now, I read in the news like companies like Facebook and Instagram are losing a lot of money because of this new policy, this Apple's policy that make it very difficult for these companies to collect user data and sell them to advertisers. So this has had a very disruptive impact on online advertising business in America. So if China adopt a provision like this, I would imagine that it could have potentially a very big impact, just like the Apple's privacy change, because the Chinese requirement is, to some extent, is even more demanding than Apple's requirement, because it's asking firms to require consumer opt-ins, not just for personalized advertisement, but also for personalized content recommendation, right? And it not only applies to the tracking of activities by third parties, which was in Apple's case, but it also applies to within app tracking, right? So it's actually have a much broader scope. So what is uncertain is whether I'm betting, all the Chinese app developers are lobbying the regulator to drop this provision, right? I mean, if they cannot drop this provision, it's going to have a very big impact on their business, because so much of what these apps are doing relies on recommendation, relies on personalization. So this is going to make a very big impact on their business.
I think you have already predicted my next question, which is what does this all mean for competition, and especially in the tech space, with a lot of platforms or tech companies that's relying on data. So I guess I'll try to ask a lighter question, lighter with air quotation marks around it. So what's your view on how data and privacy law should fit or not fit into the picture of competition? And is China's approach the right approach? And what's your view on it?
Well, I think it's still very, very early stage for us to say whether China adopted a right approach or not. And obviously, all over the world, countries are tightening data and privacy regulations. But I think we are still, at a very early stage figuring out what is the best approach to protect personal data, because one of the most important feature of data is that is non-rival in the sense that it's very easy to share, right? I mean, somebody's use of the data wouldn't interfere with others' use of data, and it's partially non-excludable. It's so that make data, have a very big externality issue, and that's why countries have a lot of concern about data sovereignty, and it's something that's very difficult to figure it out. And the United States has been very cautious in rolling out data protection, and in that regard, it might not be wrong, right? I mean, because we are still at the early stage figuring out what is the best way to protect personal data. And the prevailing and the dominant paradigm to protect data, which is based on consumer consent, may not necessarily be the best approach, because now with the big data analytics, companies can figure out your preferences without knowing your data, right? I mean, so I don't know. I mean, I think we are still at a very early stage exploring what to do with data regulation. And I actually think a more cautious approach might be better, rather than, jumping into very strict regulation that might cause huge disruption to business innovations.
That's fair. I'm going to now hand it over to Christina to a more fun segment of our program.
So, Angela, thank you for speaking to us today. But before we do let you go, we do like to ask all of our guests a few questions. The first is to tell us something about yourself that people would not know if they only knew you professionally.
I don't have any specialty. I'm a very boring person. I'm a mother of 2 kids. So like all working mother,
busy enough.
Yes. I mean, I'm always tired and busy. So I just put them to bed before this podcast, and I've been hoping they won't wake up during the show.
I'm familiar with that sentiment. And Angela, advice that you have for young professionals or students who are interested in doing what you do?
I still think that I'm very young. So my advice is that I think stay curious about what's happening beyond the law will probably be my best advice. Because if you're interested in understanding Chinese law, you realize, it's hardly enough to just understand the law, because the complexity of the law really lies in enforcement, right? So you need to understand the legal institutions. You need to understand the relevant legal actors that are involved. You need to understand the general public policies in China, the political and economic environment, or even the geopolitics. All these things could have an impact on law enforcement outcome. So that will require you to have very broad-based knowledge, in things beyond the law. And so, just stay curious and stay open, and see this as a lifelong journey of learning.
We should hire you as a marketing person for our Curious Amalgam. Couldn't agree more to our listeners to all stay curious. Our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Angela, I'm going to ask you to pick a number 1 through 10.
7.
7. Can you tell us about a teacher who had a major influence on you?
Oh, that's very easy. So my doctoral advisor, Richard Posner, a very renowned legal scholar in law economics, definitely have the biggest influence in my academic career. Even though he himself wrote almost nothing on Chinese law, but his approach to study the law, this very pragmatic approach to understand the inner working of law, does have a huge influence on my research, and also about what the advice I just gave to the students is that you always need to stay very curious, because based on my interaction with him, he's an extremely curious person who was curious about everything and very open-minded. So, yeah.
Great. Well, Angela, thank you again for joining us today. And to our listeners, never stop asking questions, and join us on the next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.